Welcome back everyone to today's video. In this video, we're going to talk about expectation of privacy by way of the Fourth Amendment right against unreasonable search and seizure. We dive deeper into the definitions of search and seizure in another video, which you can check out in the description. Today, our analysis specifically pertains to individuals who are incarcerated. It is an issue that's been contested by inmates and human rights groups alike, and it's especially important for those who are actively facing charges. Generally speaking, the expectation of privacy extends to one's home, business, car, and one's person. This includes your pockets, purse, or other containers where you carry your belongings. So, does this apply to the incarcerated? The answer, unfortunately for many, is no. The expectation of privacy does not apply to inmates. This holds true whether you are awaiting an indictment, newly charged with a crime, awaiting trial, in the midst of a criminal trial, or serving a sentence after a plea or conviction. Why is that? Let's break it down. Every correctional facility is assigned a particular level of security. That level of security, coupled with the individual restrictions allotted to each inmate, dictate what items are allowed inside the facility. Thus, anytime a prohibited item is discovered and attributed to a particular inmate, that occurrence may be used by law enforcement against the inmate. Correctional staff has long argued that the vigilance required in these facilities necessitates a different standard for what's acceptable. Courts have agreed with that position and held in countless cases that the interest in maintaining a safe and secure environment, both for the correctional staff and the inmates, is of greater priority than observance of the Fourth Amendment right in a traditional sense. Here's how that translates if you are required to spend any length of time in a correctional facility. There are several instances in which you, as an inmate, can expect to endure search. This includes when you first enter a correctional facility, after having a visit from an individual that does not reside within the facility, when there's been an incident within the facility that is a potential or actual threat to security, if there is suspicion that contraband is present, and to be honest, virtually at any point in time the correctional staff deem it necessary to carry out a search. Now, a search may include that of an individual's person, a single cell, a communal living space, or any other area of the facility. Courts have even ruled that a search of one's body cavity, while admittedly invasive, does not impede on one's Fourth Amendment rights. Again, this standard is the same regardless of your stage in the adjudicative process. Physical searches aren't the only way in which inmates are limited in their lack of privacy. Group visits, one-on-one visit areas, phone banks where there is a potential to record video or audio should be approached with caution. This is especially true if there are signs that notify you of potential recording. Not only can your movements and conversations be recorded, the contents of the recording can be used against you in court. The bottom line is this: when you place a call from a correctional facility phone, always expect that anything you say is fair game for the prosecution in your case. To learn more about your Fourth Amendment rights against search and seizure, check out our video list in the description. We're breaking down the many ways the Fourth Amendment can come into play as part of your criminal defense. Until next time, take care and be safe.